Good evening, everyone. Happy Friday. I get excited every Friday because I look forward to these Zoom webinars, and the feedback that we have received has been very, very positive. So I like to believe that we're doing a good job as an organization in trying to get you these key topics with wonderful partners to you at the comfort of your own home. And as a matter of housekeeping, and throughout the 12 months now since COVID happened, our organization has been in the front lines in terms of addressing the need at that moment. And the need that has always been since March of last year has been PPE, right? The masks, sanitizers. Our office continues to have these available to you. So if you are in need of masks, I heard today that apparently the masks are going on for $40 a box. You could get them for free at Palante. You could get one box which contains 50 masks. And if you're a senior, you could get the box if you live by yourself, in addition to a face shield. If you guys are ready to get your vaccine, just hit us up because we will also register you, whether you are in Brooklyn, Manhattan, or the Bronx. And we just want to be able to survive this pandemic. And I know we will if we all use the masks, we all use the sanitizers. And again, these things are available to you guys for free. At the last meeting that we had, we talked about E51. We know it was a little bit technical. But it's the reason why it's a lot technical is because a lot of the audience from that these last Friday, you guys were actually rent stabilized. There were very few people that were actually J51 that were not rent stabilized. And those guys, I think a little bit of them didn't understand what was going on. But if you have questions about the last session, please, just drop us an email at palanteharlem.org. And we will be more than happy to make sure that you guys get an answer, not just from me, but also directly from Tim Collins, who's the attorney who partnered with us last week. As you can see on the screen, our friend Jesse Gribben let me make sure I get this all right. Well, first of all, he's a partner, right?
I
At
am.
this awesome law firm. I never said you're a partner, you know that. I'm sorry, Jesse. And,
I
and,
know.
and we love you, man. But the law firm is Himmelstein, McConnell, Gribben, Donahue, and Joseph.
Yes,
Okay.
we like
Yeah.
to be inclusive. You get everybody's name in there.
Right. We're gonna get everybody's name because we've had Sir Joseph already. We had
Sure, just about.
Donahue already. So you guys are our wonderful partners. And we really appreciate you and you bringing your level of expertise. Today, Jesse and I, we have a special treat, and we have Sherelle. Sherelle Bernard is actually her title. She's actually an attorney at the ACR, folks. And we're really happy that she just, like, the Palante way, roll up your sleeves, step in, do this, right? And she works with DHCR. And as you know, most of you guys know that DHCR, they oversee the rent laws. So we're listening directly from an attorney at DHCR, which this is the first time, Cheryl. So I have to, I have to get bragging moments for you here.
Thank you.
And thank you, Cheryl, for stepping in and say, hey, I'm willing to talk about this. Obviously, we have COVID. A lot of our tenant of records have passed. A lot of our parents, grandparents have passed, and I think that this workshop is extremely timely because now we're about the eviction crisis. The evictions are about to begin, and landlords are going to try to take advantage of the people that do not know. Today we're going to talk about succession rights, but not just regular succession rights, guys. We're going to talk about the regular succession rights, but you're going to take it a step forward, and we're going to talk about succession right, even if you're not an immediate family member. What that means is that you're not a cousin, you're not a friend, you're not a roommate, you're not a caretaker, you're not a guardian. So we're going to talk about all these things. And again, as I always say, ask your questions, because you don't ask questions, it's going to get really tough. And again, people don't plan to fail, they fail to plan. So that being said, and before we begin, I want to just start off by finding out who's in the room. Robert, can you put up the survey? I want to know what type of housing our audience is living in right now. This way we make sure that we speak to their specific cases. So it's a quick survey just about whether you're rent stabilized, rent controlled. Do you live in a Mitchell-Lama building? Do you live in a NYCHA building? Are you a market rate tenant? Is it an HDFC co-op? Are you renting an apartment in a private house, or you just do not know what type of housing you live in? So you can just take a few minutes just to, for everyone to just like click what type of housing you live in. And if you don't know, it's okay. Just put in don't know.
Okay, 60% of our attendees have voted so far. You just, oh, keeps going up, 65%.
Wonderful.
And we'll have those results up in a moment.
What I can speak during this, what this is happening, right?
Absolutely, sure.
I am extremely honored that my personal attorney, Evan LeGros, is actually on this session. So Evan, I know you can hear me. Sorry to do a shout out, but I saw you at the last session and I'm really happy that you joined us. So thank you.
70%, 72. All right, so we may not get everybody who's putting in a vote, but we're getting up there, 74%.
Wonderful.
%. That might be our limit of participation on here, so I can always bring up those results.
Wonderful. Could you bring up the results,
All
please?
right. And here we go.
Excellent. Very good. So I see that 65% of our audience live in a rent stabilized apartment, 5% rent control, 3% NYCHA, 3% market rate. The HTC co-op, that's 5%. And if you're renting a private house, 3%, and there's 16% that do not know if they're rent stabilized. For the 16%, my immediate urgent advice to you would be to contact DHCR to find out if you are a rent stabilized tenant. And if they cannot find your bill, then it is more than likely that you're not. And we'll post that number at the end of the session. But I recommend that you call DHCR and ask them to get a copy of your rent registration history, and that will let you know whether or not you're rent stabilized. And they'll mail it to you. And once you get it, give us a call and we'll help you analyze it. So without further ado, I want to introduce both Jesse Gribben and Sherelle Bernard. I think these guys are terrific. Again, they're partners. And Jesse, do you want to go first? Sherelle, we didn't even practice about this because our Zoom or, hands-on, it's like, so who wants to talk about, who wants to take the lead on this? I'll leave it up to you guys.
Sherelle, I defer to you. You tell me. I'm happy going first. I'm happy going second. You decide.
Nope, you can go first.
Very good. I will. All right. Good evening, everybody, and welcome. And I just wanted to, again, I've done several of these over the last several months, but it's always wonderful to be here. It's wonderful to talk to everybody about issues that are incredibly important, and tonight definitely being one of those. Succession. So I'm just going to be very, very brief and provide, I guess, like a broad outline as far as succession. So we're talking about rent stabilized apartments, succession rights. There are succession rights though for the folks on this webinar who live in Mitchell-Lama housing, and also for HDFC co-ops. And generally the rules apply with some caveats, but I do want to say, sort of the remarks I'm going to give are sort of geared towards the rent stabilized, rent controlled tenants. So in order to succeed to a rent stabilized tenancy, the first thing that has to happen, and I'm going to come back to this, is that the tenant of record has to permanently vacate, right? You don't get to succession until that tenant of record. And when I say tenant of record, that's the tenant whose name is on the lease. And when that tenant of record vacates the apartment, that's when the potential claim for succession ripens. Landlords don't provide advisory opinions, right? You can't say to the landlord, hey, I live with my mom, but I'm wondering if my mom were to leave, can I get succession to the apartment? They'll say, when your mom leaves, we can talk about that, right? So there is no succession until you have that first threshold issue taken care of, which is that the tenant of record has vacated and no longer primarily resides in the apartment. And again, I'm going to come back to that. The second thing, in order to succeed to a rent stabilized or rent controlled tenancy, is you have to have sufficient co-residency. What does that mean? That means you have to reside as your primary residence in the subject apartment, in the apartment with the tenant of record for 2 years, almost always, but 1 year if you are a senior, and Sherelle might know this better than me. I believe it might be over 62, it might be over 65. I'm not 100% sure.
It's
And
62.
there you go, 62, the lower number. Great. So if you're over the age of 62, and I'm not going to call that a senior, but if you're over the age of 62, then your co-residency with the tenant of record is just 1 year. And similarly, if you are disabled, your co-residency is 1 year. What does co-residency mean? Co-residency means you're going to have to prove it, right? In succession, the tenant has the burden of proof, right? The landlord doesn't have to prove that you don't live there. You have to prove your right to succeed to the apartment. So what does that mean? You have to be able to prove that you lived in the apartment with the tenant of record. And that could go both ways. It could be the would-be successor trying to prove they live in the apartment, but also that the tenant of record lives in the apartment. And again, I'm coming back to that. That's important. And to prove that, to prove residency, right, what do you need? There's a lot of different ways, and we can sort of get into this throughout the discussion. I don't want to kind of get into every detail, but there's a lot of ways to prove that you primarily reside in an apartment. The best way to prove it, and in succession cases, generally an important part of succession cases, the strongest succession cases, have a very, very extensive paper trail. And that's because if you reside somewhere, normally that's where your important documents list your address, right? Like if you file, if on your tax returns or on your driver's license, or where you're registered to vote from, or where you're getting other documents from governmental or city or local agencies, where your bank has your address. Those will show where you primarily reside. There are other ways to show where you primarily reside, such as testimony, but it's not a great set of facts if all of your documents list another address and basically your succession claim relies on your testimony and others that's not really where you live, but that you live in the apartment. Okay, in order to succeed, you have to prove a family relationship or a non-traditional family relationship. So the family relationship is probably the easiest one to do. You can prove that you're somebody's son or daughter or brother or sister, and you prove that. You have to prove those things, those relationships, birth certificates, right? Those are ways to prove that family relationship. No longer aunts or uncles, but that's something we're looking at and trying to put back. No cousins, step parents, yes. Grandparents, absolutely. We'll get into the list, right? Those are the traditional, let's just say, blood relationships, right? That type of step isn't blood, all right? But the family relationships. But there's also non-traditional family relationships that you can prove, right? So if you're not related to somebody, you still can succeed to a tenancy. And just briefly, a historical sort of basis for this. First, through a very, very significant case, Braschi v. Stahl, and then through amendments to the Rent Stabilization Code, non-traditional family members can succeed to rent stabilized apartments. So the Braschi case, that was a gay couple. And because at that time, gay people in gay relationships, they couldn't marry, there was no formalizing of their relationship, but they were in every sense of the word spouses or family. And they were able to prove that and establish that. And since then, and that, that kind of grew out of, and since then, that's been expanded. And courts now, they do, by and large, and DHR as well, and other, they do take a much more expansive view of family, as they should, right? And family isn't always who you formalize the relationship with, or who you have some sort of structured familial tie. So what a non-traditional family member is someone who is family It's not your friend, right? You can't succeed to your best friend's apartment. That's not what you can do. You can't succeed to a roommate that you might actually, really, really be very, very, very close to, or even love, and that you've lived with for many, many years, right? You can succeed to somebody who's non-traditional, but somebody who's a familial-like relationship. And again, the best way to prove that familial relationship, that non-traditional family relationship, is through documents. That's the best way to do it. And what type of documents? For example, if you're the beneficiary of somebody's pension plan or somebody's life insurance policy, or if you're a beneficiary on their will, or if you're their healthcare proxy, or if you're their power of attorney, these are all sort of formalizing in some way your relationship, right? The way the courts look at it, they use these fancy words, like the intermingling of finances, right? The commingling of finances. And that's to some extent to show that if you're family, right, you don't have like separate sort of bank, you might have a joint bank account, you might share in the household, the household needs as far as who buys what. But again, like I said, documents, those are important. Those create the strongest cases, but they're not the only thing that can help you win in a non-traditional family case. You can win a non-traditional family succession claim based on evidence alone, based on evidence testimony alone, and not having documents. So I do want to say a couple things, and then I'm going to, get off quickly. But in the advocacy sort of world, and I'm a tenants' rights lawyer, so I hope I'm not divulging any trade secrets. One of the most important things with succession claims is, for lack of a better word, like some sort of estate planning, right? Trying to get ahead of this and figure this out, right? So take that to heart, right? If you have somebody who's dear to you, but you're not sort of an official family, think about some of what I talked about, and maybe doing a couple of those things so that you solidify that claim if and when necessary. And that's important to do, right? You could have moved back home with a parent 3 or 4 or 5 years ago, absolutely be entitled to succession, but you just never got around to changing the name on the license, or you never got around to changing your bank account, or you never went and told your employer to change your address, because why not? Because somebody else that is living in the apartment where you used to live, but that you left, right? And those create incredibly difficult obstacles if you're ever forced to litigate these claims. So you do want to think a little bit about it if you have the opportunity to go ahead and make those adjustments, if you will, to have your paper trail accurately reflect where you actually live. And in the case of the non-traditional family relationship, solidify that relationship through some of these things that I talked about that courts really look to as far as establishing that claim. And then the last thing I'll say, and this is incredibly important and something that I think is going to generate some discussion this evening and questions, but the critical thing here is what I opened with, is that you don't get to a succession claim until the tenant of record has permanently vacated that apartment. And what happens all too often, and we see it all the time, is you'll have a situation where the parents live in an apartment for decades, and the parents then gradually, right, not all of a sudden, they begin to spend a little more time away, right? Maybe they, retiring and they're spending time, down south or in Puerto Rico or in DR, and they're coming back to New York, but at first they're coming back somewhat regularly, and then that starts to get a little bit less regular, to the point that they're not coming back that much. They might come back in the summertime for a week or two, and maybe another time, but basically they're not living in the apartment. But because there's some nervousness about this, they continue to sign the lease, right? And they continue to send the checks in their name. And then, and that creates such a dramatic problem when you want to assert the succession claim. Because what the landlord then will say is, okay, prove that you lived together for 2 years, and the 2 years before the tenant permanently vacated. And let's say you do that now, but for the last 10 years, what's been happening is what I described. Well, how do you show that you lived together from 2019 to 2021 when during those years, that's when they were not in the parents weren't in the apartment too much? So you say to the landlord, well, I'll show you that we lived together way back when, right? Back in the, the late 90s. I'll show you that. And the landlord says, no, you don't get to do that. You've been signing the lease. And that creates a really, really, really difficult dynamic. And we've seen horrible, tragic examples where generational apartments that are in generational apartments, right, are lost because of this inability to kind of just vacate as soon as it becomes really clear that the tenant of record is not living there. That kind of prolongated, period of time where a tenant of record is signing a lease and paying the rent, that becomes a very, very, very difficult obstacle in succession claims. A little less so in Brooklyn and Queens because of the way the court system is and different, and there's a split in the way courts have decided this depending on where you are. But certainly for the folks and the majority of folks in Palante, right here in Washington Heights and Harlem and up in where I am in Inwood and in the Bronx for sure, that's all. This is certainly not great law where we are in the first apartment. So certainly something very, very, very important to keep an eye out for. And we'll talk a little bit more. I want to get off and let Sherelle speak and others, but we'll talk a little bit more, I'm sure, about this issue as we progress. So thank you.
All right, thank you. Good afternoon and good evening, everyone. My name is Sherelle Bedard. I am Special Counsel for the Office of Rent Administration. Alcia, I'd like to thank you so much for inviting me and having me at such short notice. Our office is responsible for administering the rent regulations for rent-regulated tenants. And tonight, as Jesse explained, we are talking about our succession rates for rent control tenants as well as rent stabilized. Jesse did a very good job at explaining the variances that we have within our what we look at to establish succession rates. There's two things that I wanted to touch on outside of what he spoke about. First, in terms of the tenant of record vacating the apartment, at DHCR, we also look at whether or not the tenant has passed. So that vacancy can either be due to the tenant moving out of the apartment or it could be due to a death. But you must have 2 years prior to either the vacancy or death of the permanent tenant of record in order to claim succession rights. The second thing I wanted to touch on was our family members. So we have truncated what we look at in terms of creating this family member relationship, but we still look at mothers, fathers, step-parents, siblings, and domestic partnerships is something else that we look at. And we also have taken a step outside of that, and he talked about the non-traditional family member. So we look at anyone else that could be considered a family member, but doesn't have the family, sort of prototype of a DNA to actually say that they're family. And for that, we look at the economic as well as the financial commitment between the two parties. So we look at the longevity of the relationship, the reliance on one another, and that they rely for interdependency, for housing, medical. We look at any legal documents that you can provide. As Jesse spoke about, we look at wills and domestic partnership agreements. One of the, I think the most challenging issues that we see at DHCR is the actual proving of a relationship for issues, as he spoke of a snowbird. When you create that disparity within time, it's hard to prove that you've actually lived in that apartment for 2 years because there's a space. And when we look at prior leases, even though the tenant of record has signed the leases, their permanent residency in some cases may have changed, right? So they may have changed their address on their license, or they may have changed their address on their bank records and they're living abroad, or they're living in another state, but they're still signing the actual leases here, and that causes some type of confusion. So we try to do our best to eliminate that type of confusion. There is a form that I spoke to Alcia earlier about, and that is the RA 23.5, where a tenant can provide notice to the owner of the family members that are living in the property or that particular unit, and they can update that as much as possible. But a landlord can only request the, I guess, he can only request the amount of names that an apartment unit may have, right? So a list of tenants in that particular apartment or occupants in that particular apartment once within 12 months. So there are ways to notify the landlord of who is in the apartment, and there's ways for the landlord to particularly get information about the apartment. We also have minimum requirements too that do not disrupt that right to succession, and that is if you are active duty in the military and if you are a student away at college. So those are two other exceptions to the rule. I think that pretty much covers it because succession hasn't changed with the passage of HITSPA. We have a fact sheet 30, that is available to everyone, which outlines everything that Jesse and I have covered. And we can actually start with questions if you like, Althea.
Alcia, your microphone.
Hi, yes. So let me ask you something, Sherelle. One of the key things is that sometimes, we have people we call it with papers and without papers, right? Meaning that they don't have a green card to be in this country, but they're, in the process of paperwork. Does succession affect that? In other words, would a landlord be able to deny them the right to have a succession rights if they don't have any papers to be in this country?
That's an issue, honestly, that we have not come across, and that would require special attention. It would be on a case-by-case basis. So if someone was to come in and they was to claim residency within that apartment and not have residency as, I guess, a citizen of the United States, that's something that we would have to look at. I can't give a blanket answer for that because each case is different.
Let's see if I could. Yeah,
Yes,
so
please.
so the answer though is as far as the courts though, the courts have looked at this and the courts have opined that immigration status is not a criteria and that one can establish primary residency. The landlord's argument is you can't be a primary resident of a New York City apartment if you're not here with papers allowing you to be in the country, right? So, but the courts have actually taken this on, and the courts have said that being a primary resident, as far as the rent stabilization law and code, is not barred by one's immigration status or lack of papers, if you will. And this actually is a succession case in the Bronx, originated in the Bronx, and in that case, it was a woman who was trying to succeed to her deceased husband's rent stabilized apartment, and the landlord made those exact arguments, right? That nope, she doesn't get, not saying that they weren't married, not saying that they didn't live together for many years, just saying she's barred. Her immigration status bars her from succeeding, and the courts rejected that argument, and that's now become, it's become though a pretty much a sort of an established now doctrine in the courts with regards to immigration status and landlords not being able to question tenants about status, and certainly not denying tenants based on their immigration status.
So let me ask you a question. How does the immigration status works when, because we know, right, that landlords like to have just one name on the lease, right? Not immigration, that means succession right status. But then by law, a landlord is required to add the husband and wife to the lease. So Cheryl, do you want to talk about what does that mean for succession rights? Do both extended family members have succession rights, assuming that they live there? How does that work? If there are two names on the lease, husband and wife, and if there's a priority, so let's say if one of the spouses passes away or the other spouse decides to move out, how does that affect the two lines of succession rights?
Well, if one of the family members decides to move out, the lease can be updated, but it's different. So if it's a husband and wife, they will update the lease immediately. So say Mary gets married and now she has a husband, she can update the lease upon lease renewal of the husband's name, or she can add the husband's name at the time that she has the documentation to prove that they're married to the landlord, without risk of a vacancy increase or anything of the like. If it is a child, usually the landlord would wait till lease renewal, and then they could remove the tenant and then add the children. And sometimes landlords in particular cases may ask for documentation to prove that that is a family member going forward. And that's, again, why the form is so important, because the tenant can actually notify the landlord ahead of time of the occupants of the apartment.
Mhm, mhm. So what about if Jesse, what about if I, God forbid, let's say I passed away and then I have an underage child, can my kid get the lease under his name although they're minor, under 18?
Yes, the answer to that is yes. A minor child can succeed to his parents, guardians, stabilized tenancy. The way it would work practically is whomever becomes that child's legal guardian, if that child's under the age of 18, they would reside, I guess, in the apartment with them. But yes, absolutely, there are absolute cases in which a minor has succeeded to a rent stabilized tenancy.
And can the landlord demand that they show income, like they have to have some sort of income in order
No,
to have the lease under their name?
No, income is irrelevant to a succession claim, right? There is no, means test or some sort of, that's not a factor. Anything the landlord can ask for when a tenant claims succession.
So just to make sure that we all understand. So let's look at the worst scenario. The worst case scenario is that the tenant of record did not win the lotto. That's why they moved. That the tenant of record instead has actually passed away. So if I'm a tenant that my mom, my grandma, my sister, my brother, my grandma, grandpa passed away, so I need to obviously have the death certificate, right? Because I have to show the landlord that the person has vacated the apartment. Then I need to find a birth certificate to show the landlord that I'm actually related in those lines, right? And then what about if I've been living with grandma all this time and I move out and then I come back right around, COVID, and it's only been a year, and then God forbid grandma passes away. Can I keep the apartment? Since although I lived there when I was born, I moved out and came back in.
Yeah, good questions. Those are difficult cases too, right? And we see those a lot, where again, it's an apartment that's in the family forever, and there's certainly a tie connection to that apartment over decades. But the critical fact in a succession claim is not how what the tie is, right? The totality of the circuit. It's about, can you prove what you need to prove, and that would be the 2 years of co-residency, except if you're 62 or older or disabled, 2 years of co-residency prior to that tenant of record either dying, and again, dying is actually the cleanest vacatur of an apartment, right? I mean, I don't, when a tenant dies, that's clearly they vacated the apartment. What's less clear is what we sort of talked about a little bit too, is when mom or dad or grandma, leaves and they're living somewhere else, right? And sort of that desire, and I understand it, to like not rock the boat, meaning let's not change anything, let's just keep this going. We got the affordable apartment, and let's not mess that up. I'm not telling the landlord, and that often becomes a real big mistake. But the example that Alcia gave, that could present as a really, really tricky and tough case, right? If you have a situation where somebody could live in an apartment with their grandma for 20 years, if they leave and it's not to go to school or some other excused absence, the military, and they come and they're somewhere else and they move back in and they're only there a few months, and then, grandma passes away, that's a tricky succession claim. That might not be a succession claim you can win.
One of the things that I've heard of as we come across these clients is that the landlord says, okay, well, give me all these documents and we'll get back to you. Can a landlord do a credit check on our succession rights?
No, there's no, this, yeah, any sort of like financial inquiry is inappropriate. In fact, you know, they can get copies of your, for example, your banking records or your credit card statements, right? In this day and age, and what, and I'll say this too, so for everybody, it's important. Your digital footprint, right? That means everybody now uses an ATM card, they use a debit card, they use a credit card. And if you look at your statements, and people should do this, it tells a real telling story about where you are. And if you're saying you're living with grandma, you know, in Co-op City or something, you know, Co-op City is not a good example, it's not a rent stabilized apartment, but you're living with grandma in a rent stabilized apartment up in the Bronx somewhere, but you got every, you know, credit card swipe is at the bodega at some place in Brooklyn. That doesn't look great, right? That looks kind of like, you know, right, what's going on. Now, if it's by your office or something, okay, but, you know, it tells the story. Now, landlords are entitled to those types of documents, not to see what you spent, right? They get no information about the amount of money that you swiped on your card or you took out, but they get to see location, because location is the inquiry often in the succession context. So they get to see where you are. And I'm telling this to people, it tells where you are. It really does. You know, if people drive, they get Easy Pass records, and where you're going through a toll is going to show sort of your pattern and where you are. People, you know, it's getting to the point, and we're resisting this a little bit. Landlords are trying to use people's cell phone data, right? You know, the same way the cops look when they, and where you're, you know, they subpoena, they get your Verizon records, where you're pinging, right? And there is some real issues with that data. But if you're pinging off of a pole, like in Washington Heights, and you're trying to succeed through an apartment in Brooklyn, and every single call is from, it doesn't look good. It doesn't look like you live there. So, you know, they don't get any financial data, but they do get that data to see where you are. If that, I hope I'm making case. You redact every single number because the numbers don't mean anything and they're not relevant, but your location means everything.
Yeah. What about if you have you living with mom, dad, or grandma, grandpa, and you've been living there for 2 years, but you own a house, let's say in Georgia or somewhere else in the United States, can the landlord use that against you to get your succession rights?
No, you're allowed to, if you're a rent stabilized tenant, you're 100% allowed to own another house somewhere. There's no prohibition against you owning property somewhere else, in this country, in another country, in the city. There's no prohibition. What you're required to do is primarily reside in the apartment, right? So if you're doing that, then that's the criteria. Same thing for succession. You might have a house, but if you're not living in that house and you're living in, you know, mom's house, mom's apartment, or grandma's apartment, that's where you're living. The house won't be the barrier to you getting succession. With that said, if you have those things, take to heart my estate planning tips. Make sure, though, then you start doing certain things to establish your primary residency in the apartment, right? So, you know, and these are the type of cases that we do, right? Tricky cases, if you will, cases where, because let me just be clear, you have a house and you've lived in that house for a long, long time. And then you say, I'm living with grandma, and you do nothing. You don't change a document. You don't have anything from a moving company, right? If you're really moving in with grandma back to the apartment, right, it stands to some reason that you would take some affirmative steps to change where your address is, right? So you should do that, meaning you should tell your employer, I no longer reside at XYZ, my house. I reside with my grandma. Here's my address. Start sending your change of address forms to different people. Start changing your address to accurately reflect where you live. Because unfortunately, sometimes it's absolutely true that you left the house and you live in the apartment and you should be able to succeed. But oftentimes succession cases, it's not like a fact-finding truth commission. It's an adversarial proceeding. The landlord doesn't want you to get that apartment, and you have to prove you're entitled to it. So, sometimes, like, the truth, the truth doesn't always prevail. Right? Sometimes you have to do some things so that you can then, create your proofs and convince a judge or convince the HCR that you're entitled to succeed to that apartment. So the house doesn't bar your claim. It's not but it is an option. It is something to certainly to have in your mind and think about, and to take affirmative steps to sort of mitigate against that.
This is terrific. And Sherelle, what about if I'm a rent control tenant and I live with mom and dad? It's totally different procedure with the HCR, right? Because if you're rent stabilized and after you tell the landlord, Mr. Landlord, my mom or whoever it is passed away, they left the apartment, and they provide all the documentation that we just talked about. What about rent control tenants? Because rent control tenants don't have leases. Most of them don't.
No, rent control tenants do not have a lease, but we look at the timing that you have lived in that apartment and whether or not you're subject to eviction. So if you can prove that you lived in the apartment, we still keep the same 2-year guidelines for 2 years, and you're subject to eviction based on either the vacancy due to death or the tenant moving out, and you can prove that you have the rights to succession, then we will process the case as is. And we hold to the same 2-year time period for vacancy, or the 1-year time period for disability or senior citizens.
So does that mean that the apartment rent change on rent control, or does it stay rent control and can I keep the same rent?
No, it should stay rent control. They should keep the same rent. And the same thing with rent stabilization. Because of HITSPA, our vacancy increases have changed.
Define HITSPA. Hold on a second. Those are fancy words now.
So, I'm sorry. The Housing Stability Tenant Protection Act.
That's the new rent law.
Yes, the new rent law that has taken over my life for the last couple of years. And it's a shame, right? So it's already been 2 years since this law has been passed.
Yeah.
And we, with the passage of HITSPA, vacancy has changed. So the landlord isn't entitled to a longevity or any other type of vacancy increases unless it is the vacancy increase that is voted upon by the RGB for New York City, Westchester, Nassau, Rockland. And we look at that, and that's what the increase should be when you enter into the apartment.
Wonderful. This is great. This is, I really, I know that there's a bunch of questions, but I want to make sure that we cover everyone here. In terms of
I am
rent
so
guideline
sorry.
board.
That's
It's
the rent
okay.
guidelines board. You get so hung up on these acronyms all day long. So I truly apologize.
Our members only know the acronyms of the agency. So we got the DOB, the DHCR, the HPD. We got to move on to the other ones. But this is really, really terrific. One of the things, and I like to always say, our folks in West Harlem, in Washington Heights, we have a tendency of saying, well, we have a trusted mailbox, which you could be at our parents. And this is where we get our immigration papers, any legal papers we get there, but we live somewhere else. And so we kind of split our ID paperwork. So we'll have a driver's license at our real address, but our trusted address, meaning when they first came from Mexico, when they first came from the Dominican Republic, that home is almost like the holy mailbox. That's what we call it. And we try to tell tenants, like, you got to move away from the holy mailbox and use that, because landlords will start asking for that. Landlords also, in the middle of all of this, they love checking out passports, especially if you're Dominican and Mexican. If your original origin and your family is overseas, anyway, you have to cross, you have to cross the ocean. They're going to start asking for that. And that's how they get us. That's how they get us, because the passports get stamped every time we move out. And, and that's how a lot of landlords have been able to take away our rent stabilized apartments in Washington Heights and West Harlem and in Central Harlem. So we always say, you have to fight. If you want to live in New York, you're going to have to fight at some point in time. The question is, you're going to have to fight now or later. But it's better than, instead of waiting and postponing this fight, if the landlord doesn't want to give you a lease, it's better to take it on now. And, again, it's also not just when someone passes away. If the parent moves out, all the landlord or the person needs to do, assuming that they have the direct family member that's been living together, which is what Desi and Sherelle are talking about, co-occupying, you got to live together for 2 years. But if the person's alive and they want to move out, they can just write a letter to the landlord saying, landlord, I would like to have the lease passed over to my daughter, my son, right, Jesse? I mean, it's not rocket scientist, right? The landlord cannot say no.
The landlord can't. Well, I mean, so let me just say, make sure we're clear though, because this happened. This is it's not succession exactly, but related. A lot of times people will ask me, I asked the landlord to put my son on the lease, and the landlord said no. Or I asked the landlord to put my, my grandchild on the lease. He said no. And to be honest, the landlord can say no. And again, that's something I think we're looking at is potentially, an issue that needs a legislative fix. But right now, the way the law is the only relationship in which a landlord has to add somebody to the lease is if you're a spouse, right? If you're married and you present the marriage certificate. If you present a marriage certificate, the landlord can't say no. And the landlord must put that spouse on the lease, not right away, but at the next renewal. So that's sometimes like a little, but the next time the lease renews, they have to put them on. And if they don't, that violates the law. But I think, Elsie, but what you're asking is, yeah, there's no, so a lot of times the time to do this is like now and not later. And I think that's what you're getting at, right? Which is like, and I touched on that too, and it's just so important. So we'll say it again. It's, I understand it too. It's everything is okay now, right? I'm here, nobody's bothering me. I'm paying, the rent's getting paid. I'm not going to cause any waves. The super knows me. He likes me. I'm not. And that often or almost always is the wrong instinct. And that often or almost always might get you a year or 2 or 3 or 5. But at some point, there's a problem. And if we just would have taken that case on at when the tenant left, right, they would have been able to stay there, and then we can't. And that I can't stress that enough. So I guess the advice though, and I'll see it, tell me if I'm out of line though, if you think you might be in a situation as if we're describing, you should reach out to Palante.
Yeah,
and they
absolutely.
provide resources, and they can talk to you about that and consult with lawyers like myself and others, and we can give advice, right? It's not, and don't think, oh, I did exactly what the lawyer on the webinar said I shouldn't do, so forget it. No, reach out. It's better to do that now than to do that let it just keep going. I can't stress that enough. And if it is a situation, and I'll tell you, let me just say this, because if it is a situation in which it's bad, we'll be honest with you and say, no, it's bad. And maybe the best advice at that point is sit tight and let's play this out for as long as we play it out for, because and we'll tell you that. We'll be honest. I've given that advice all the time. And sometimes, not often, but sometimes we can fix it. And how do we fix it? We can bring grandma back. And grandma comes back for a couple of years.
Actually,
I've done that
you took the words right out of my mouth. Here's a case we had.
Here grandma's coming back to the apartment. Now she's pissed about it. She's angry. She's not making you dinner no more, but she's coming back because she wants to see you have that apartment. That was lots and lots of times.
We actually had a case like that where the landlord had the mom in court, but mom was taking care of her mom in Florida. And it was in the middle of the lease renewals and everything. And the son came back, the son, now the grandson, right? Came back and moved in. And we say, well, he's gonna stay in the apartment, right? Yeah, he's gonna say, okay, so bring mom back home from Florida. We're gonna do the lease renewal. We're gonna do a 2-year stint like we need to do together. And then right now we're upon lease renewal. And yes, we're gonna be successful. And there's another case also where I do not know how we did this case. It actually came out in Univision, Channel 41. I myself was shocked, Jesse and Sherelle. I literally was like, what? Like we did this? But they were partners, right? Domestic partners. And the partner left, cheated on our client, left the state. And the partner that was in the apartment was so pissed off that she destroyed every picture, anything you can imagine that would put them to show that they were together as a couple. And it turns out that we prevailed, and the tenant has a lease under her name. But it was one of those like going, okay, how do we don't even have pictures. They're not legally married. They're just living together. There was any documentation that proved that these people had a relationship was gone, like totally gone. And yet today, she was able to get a lease renewal under her name and paying with the same rent. And this is like you said, Jesse, it's like just because even if you messed up and because you didn't we didn't do the seminar sooner for you, there's still a way that you could go back, So the key thing is, there's two ways of doing these cases. One is trying them at DHCR and then trying them in court. So Sherelle, explain to me. So I'm a tenant, I can do an application, right? I can come to Palante, we'll package up the application, send it to you guys.
Yeah, so they can come to Palante, you could do a lease violation complaint due to succession because you believe that your name should have been added or you're entitled to a new lease, or because DHCR shares concurrent jurisdiction with the court, you can also file a complaint with the court. And I think it's important that Jesse is here because there are a lot of cases that take place in the court that DHCR is not aware of. And we find out on the back end different issues that can affect us and how we look at complaints going forward. So I appreciate your commentary because we don't look at fixes, right? We look at the information that we have before us. The rent examiner will look at it. If you meet the criteria, if you follow through with all the processes, then we can go ahead and issue our decision. In court, they give you a little bit more leeway with certain issues. Outside attorneys, we have, creative minds, we work together and we say, okay, well, you know what, let's fix this. They don't know about it. So let's go ahead and do this. That opportunity is information that we can advise you of, right? We are here for rent regulated tenants. We implement the law and we follow what our regulations say. So I guess circling back, the easiest thing for them to do is to work with you, make a determination on whether or not they feel that it's best efforts will be put forth through DHCR or through the court. And it's also important to note that you cannot file two complaints. You can't file one with DHCR and one with the court. Sometimes the court will succeed and say, we'll rely on the determination of DHCR, or we'll stall the case based on whatever the court may say.
So, but if I'm a tenant and I file an application with DHCR beforehand, right? And then because of everything that could happen, the tenant of record passes away, I can ask the courts to ask you guys to finish up with your determination, right?
Yes, you can. You can ask the court to stay the case and you can say, I have a complaint that's currently pending at DHCR. I'd like to stay this particular action and work with DHCR. They may stay it or they may dismiss it, and if they dismiss it, you can go based upon our determination. And it's important to note that we have our own appeals process. So when we start with the rent examiner. The rent examiners, they look at the case, the rent administrator issue the order. If the order is not to either party's liking, right? If the landlord doesn't believe that he still should give this lease, or the tenant believes that they still are entitled to this lease, they can appeal that and it will go up for a petition for administrative review. If the order on petition of administrative review is not suitable, they can then file an Article 78, which will lead them back into the court system.
And that's an appeal. And Article 78 is an appeal, right?
Yes, it is.
Wonderful.
It's an appeal of the appeal.
Of the appeal. Great. And Jesse, if a landlord wanted to take me to court because he found out that my spouse passed away, or that my mom passed away, that was a tenant of record, what are the documents that I should be expecting? What is the proper procedure for a landlord to take me to court because the tenant of record either left, either passed away, but vacated the apartment altogether? What should I expect? What sort of paperwork and what order and timeline should I be getting them? Because it's not 1 to 3 eviction, right?
No, it's not. And a lot of times, I got to say this, a lot of times if you have a real strong case, the best thing to do is to try to go to your landlord and establish your succession claim informally, right? Like we'll write a letter to the landlord and assert the claim and attach documents, which I'm going to talk about. But if you're in an apartment and, a family member passes away, you don't have to worry like the landlord's coming in and going to take the door down and put you out. There's no self-help in New York. There's nothing like that. What the landlord can do, if the tenant of record has died or has left, and they think that somebody's living in an apartment that's not authorized to be there, There's a technical legal term for that. They call them a licensee, right? That's what they call them.
Right,
And
right.
they bring what's called a licensee holdover. And that's just simply the landlord seeking to evict someone. And it, without the legal fancy language, it's saying, I didn't rent this person this apartment. The person I rented this apartment to invited this person in. And the person I rented the apartment to no longer is there because either they died or they've left. And this person has no right to be here. And the court should let me evict them, right? And in turn for that, right? And sometimes that's exactly what we're looking for, which, because in the defense to that is exactly what the topic of this forum is, right? Which is, no, I'm not a licensee. I'm a legal successor, and here's why. So the documents, the most important documents, I talked about this, but one more, I'm going to say it again, is the most important documents are those, usually it's those like stuff that you're giving to the government. That's the way I look at it. Like your taxes, your license, your voting registration,
Mhm.
Where you got your library card, where you're getting your, anything with the governmental, if you get some sort of public assistance, what address they have for you, HRA has for you, if that, they're where if you have children at your child's school, what is the address you've provided the school? Then there's all sorts of other
You
stuff.
got your
Like,
vaccine. I mean, and your vaccine from when you came to this country,
that's
right?
exactly,
Things like that, or
yes,
even the COVID vaccine right now. Yeah.
absolutely. Yeah. Medical, I was about to say that medical documentation, like where you're getting
Mhm.
where your doctor is sending you, invoices, or where your doctor is sending you stuff is very, very, very indicative of where you live, right? You trust your doctor, or and you're going to give your doctor the actual address where you are. So what you're giving your doctor is also what your medical stuff, your healthcare insurance or whatever, that stuff also very, very important as far as
Mhm.
documents. And then the other stuff that we talked about, like what address does your credit card company have? What address does your bank have? What address does your employer have? Right? Those are very, very, very important documents.
Mhm.
And I will say this: it can be a big, big burden to produce 2 years worth of documents. Like people always say to me, "Do I really have to give them 2 years of my bank statements?" And the answer is, yeah, you do, right? Do I, again, redacting everything about the money just to look.
Right.
I have
Right.
to give them 2 years of my, credit card. Yeah, yeah, you got to give them. And a lot of times, what landlords do, unfortunately, is they just try to wear people down about that. They say, you didn't provide this document, and you're like, I gave you 10,000 things. Why do you need this last thing? And it does become a little bit of a, of a burden, but it's a burden that you're going to have to, because we have to meet that, right? We have to, that you have to comply with that. And I've seen, unfortunately, tenants lose succession cases simply because they just weren't sort of able to get those necessary documents together. And that's always a shame. But yeah, but those are the most important docs.
Well, this is great. And Robert is texting me, letting me know that we have a bunch of questions.
Bunch.
I never want to get to it. So sorry, Robert, to out you like this, but I appreciate this about teamwork. For those of you guys have not know, Robert and Daniel, those are the guys that keep this engine running, these Zoom calls. Daniel is doing the simultaneous translation side, and Robert is he's just Zoom. He's controlling everything around Zoom. We cannot take credit for that, but we love these guys. So Robert, why don't I Cheryl, do you have any more to say before we move on to questions? What do you think?
Oh, no, I'm fine. We can
Yeah.
move on to questions. Mhm.
Okay, great.
Yeah, just some really great ones that have been coming up in the chat and the Q&A. So we'll start off with many times in subsidized apartments, a tenant may not report an adult child or spouse due to paying an increased rent from the additional income. When the tenant of record dies, is the unreported occupant liable to pay back rent from the unreported income if they prove residency to succeed the apartment?
Jesse?
Sure, I'll try that one. All right, so it's a little bit different than what we've been talking about, but a good question. And the answer there is probably yeah. I mean, that's probably what will happen if you have an adult occupant in a in an apartment that's where you have to verify your income. And there's various sort of forms of that, right? So I'm saying that broadly, meaning every year you're providing some sort of income affidavit. And you do not disclose an individual who's residing in your home who has income. First of all, that's a big problem anyway, because that could be an independent ground for eviction. I don't want to sort of do the horror story things, but I've seen people in this situation where they didn't report income, and it's like you wouldn't believe, like sort of the draconian sort of ramifications of that. But yeah, what you raised in this question that's important, because what I think will happen there, and what I've seen happen there, is what they'll say is you can't have it both ways, right? You can't say this individual is living here and has lived here, and at the same time not pay rent accordingly based on him being there. So yeah, I think that in those situations, probably the thing to do would be to sort of own up, if you will, and say, yeah, you know what? He gets the right to succeed because he lives here, but we might owe you guys some money because we didn't truthfully report our income.
Should my adult child who grew up in my rent stabilized apartment and has now moved into her own first apartment continue to keep her main ID documents at my/her childhood address in case we can eventually work out for her to succeed to this place?
All right, so let me try that, because maybe I've given a little bit of, let me be very, 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 very clear about this. Succession is dependent on where you actually live, right? It's not about, the documents help, but the documents aren't as important as where that individual actually lives. So for your adult daughter that has left your apartment and is living somewhere else, while she can keep some documents at your apartment, and she's welcome to do that, that will in no way, shape, or form have her win her succession case, because ultimately, at some point, she's going to be put under oath, right? Or have to put in an affidavit or a sworn statement that she primarily resides in your apartment. And no lawyer, no advocate, nobody is going to tell you it's an apartment and it's important, but it's not worth committing perjury over, right? It's not worth putting yourself in jeopardy by perjuring yourself and lying about something that's not true. So yeah, people here, let me put it this way. When people come to talk to me and about a succession claim, and the first things they begin to talk to me about are, well, my license is at the apartment and I file taxes from the apartment. And in my head, I'm thinking, maybe that person really doesn't live in the apartment, right? Because what they're doing is they're focusing just on those documents and not on, that's my home, that's where I live, right? So don't get confused about sort of the paper trail. The paper trail is secondary to the most important thing, which is that you actually primarily reside in the apartment, because that's what you need to do, right? You can win a succession claim having no documents. It's possible. It's not likely, but it's possible, right? But I don't think sort of you should have in your head, if my daughter keeps a few documents or things at my apartment, then that'll enable us to succeed at some point in the future, because that doesn't do it. What does it is if she actually comes back and lives with you at some point, then that would do it.
I live in NYCHA and OBAC rent due to the pandemic. This might not be on topic. What do I need to do to?
So if you live in NYCHA and you could show that you have been affected by COVID financially, you could actually go to NYCHA management and get your rent restructured. I know that there are some benefits around for folks that live in NYCHA and project-based Section 8 buildings. So I think the first thing you need to do is go to the property manager and explain to them the situation, and I'm sure that they'll work something out with you.
If regarding immigration, federal housing usually doesn't allow non-citizens or illegal residents in federal housing. How would succession apply in federal housing?
That is, Elsie, you want to talk about that? That is, I think that is true, right? There is some other heightened restrictions with federal housing.
Well, it's actually, no, can you repeat the question again?
Question as written out regarding immigration. Federal housing usually doesn't allow non-citizens or illegal residents in federal housing. How would succession apply in federal housing?
Well, that's actually not true. If the person, and they're not illegals, nobody here is illegal. We're undocumented. But if the person, and I know this for a fact, that there have been families that have been moved to federally subsidized buildings that do not have papers, specifically NYCHA residents. There have been times when these families have been affected by fire and it's not like these guys are applying for NYCHA the regular way that we're doing it. But if their apartment got burned out, their building got burned out, they're placed temporarily in these city shelters. Assuming this is a family, not an individual. And the city and HPD would work with those tenants to put them in federal housing, although they are undocumented. Now, that doesn't mean that everybody in the apartment is undocumented. That means that there's a child there that was born in this country that is undocumented. So the child obviously will need a guardian to be able to live there. And unlike the regular folks that were born here or U.S. citizens, their rents do not go in line with 30% of their income. That doesn't work like that either. So I think it's important that we show that. And when it comes to succession rights, I would say that the only way that you could get succession rights in a NYCHA building is actually if you were, or federal subsidized building, if you were a part of that composition. Now, if you do not have papers, then you're gonna have to find another kid that lives in that building, in that apartment, that has a social security number, and then the guardian will continue to remain in the apartment. I hope that makes sense. Does that make sense? Jesse, or did that sound confusing? Because I know that we've had cases like this before.
No, it made sense to, it made sense. Something I learned too. It's good.
Yeah. Next question, Robert.
I'm not sure I missed this. If my paper trail says I have lived with the tenant of the rent stabilized apartment, do I need to be on the lease for the succession to work?
No, in fact, succession means that by definition, you're not on the lease. If you're on the lease, you're a tenant of record. So there is no succession. You're just the tenant. By definition, succession is when you're not on the lease. Remember what I talked about. It's hard to get on a lease, right? You have to be a spouse to get on a lease, unless the landlord just does it out of the, because they want to, but they often don't. So yeah, succession is different than being on the lease. Succession by definition means you're not on the lease.
With succession rights, how many generations are they eligible to succeed? Is there a limit?
Sherelle, what do you think?
Yeah, good question.
Honestly, we don't have a limit. The RSC or rent stabilization law does not put a limit on how succession can pass from generation to generation and when it should stop.
Yeah, we've actually seen some situations where we've had parents, and Elsie, you've probably seen this too, parents, the kids succeed to the parents, and then here comes the parents back again, succeeding to the kids. So we've seen like that cycle a couple different times, and that's always, people succeeding back to the apartments that they had their children succeed to. We've seen that.
Yeah, I think it's important to know that, and these are just on specific cases that we've seen, that landlords have been so aggressive, especially in Fort Washington, in Washington Heights, the large apartments, these large rent stabilized apartments, that landlords would actually try to find the tenant of record living somewhere else, and they'll call that house. They literally will call and speak to the tenant and say, hey, I'm trying to get a hold of, let's say, Julio, and there's Julio answering the phone. This is Julio. And then they will say, well, this is not your primary residence. I think it's really, really important that all of your documents are there. And even if it means that, you bought a house for the next, you're going to live there for the next 10 years, transfer the apartment over to the kids or to your sister, as long as you could prove that you guys co-occupy the apartment. Because like in the case in Fort Washington that we had, the person moved out, but did not allow his sister-in-law to apply for succession rights. And both he and his wife were on the lease. And it turned out really ugly, in that case. It was very, very long case to be honest with you. But the idea is that you can always come back and get succession rights if you want the apartment back. Roberto?
Yes, next question. I had been living, I'm sorry, how does an apartment succeed to multiple children on the lease, all adult children?
It's a good question. Then the answer to that is you can have more than one successor. If you meet the criteria, multiple people can succeed to a tenancy. We've had plenty of situations where 2 or 3 children and you get all of them named on the lease if they all meet the criteria for succession.
I did not know that. That's awesome.
I had been living in a familial relationship with the tenant on record, my girlfriend, until she passed suddenly in April of 2020, days after she had paid the first month's rent of a newly renewed lease. I called the landlord at the time and asked to have the lease transferred into my name. My landlord asked that I continue to pay rent on the lease and we would review later, quote unquote. Last week, a new landlord took ownership and asked for proof of residency. What should I send and should I be concerned?
Yeah, you should be concerned. This is very, very fact specific. So you're gonna need to reach out to Alcia and Alcia if you need, let me know. This is one of those cases, but yes, you should be concerned, and we got to talk a little more about your facts. It's not the fact that you're paying rent is not a bad fact. Then they're taking rent from you is not a bad fact, but it's not going to be a dispositive that you're the tenant of record. So yeah, absolutely, you gotta get in touch and something you have to look at and probably now.
The person who asked that question should call our office on Monday at 11 a.m. and ask to speak to Jacari. And Jacari will get us all connected. Jesse, I know Jacari will be in the office.
Good.
And our number is 212-491-2541. Next question.
Yes, in Spanish, it's a brief one. ¿Los inmigrantes pueden calificar?
Yes, of course, with or without papers.
Good evening. My father passed away May of last year. The lease is under his name. Lease terms on August 1st, 2021, and landlord has not changed the lease under my name. I lived here the last 3 years. I've been paying the rent on time every month. After my father passed away, what do you advise?
Well, that's another a case about you are entitled to a lease renewal. So upon lease renewal, the landlord should, if you provide the documentation, transfer the apartment into your name if it has been a solid 3 years that you lived there prior to the passing of your father. Alcia may be able to assist if there's an issue with the landlord not doing so.
Mm-hmm.
I suggest that the person that posed that question call the number that Alcia just gave and speak to somebody at Palante, and they can assist in that process. But that's what you should do.
If going back to, we have a bunch more questions coming in. I don't know if my apartment is rent stabilized or rent controlled, and if it's not, do I still have a right for succession?
Well, to find out if the apartment is rent stabilized or rent controlled, you should call the Office of Rent Administration. Palante can give you the number, or you can have someone in that office reach out and serve as a third-party representative to get a copy of the rent registration information or to see if that apartment is registered. And if it's a market rate apartment in terms of succession, Jesse, I'm going to defer to you.
Yeah, there is no succession for market rate apartments. So if you're in a market rate apartment, then there's no succession. Succession is a creature of rent stabilization.
Now, I know that there's some folks here that are living in city-owned TIL buildings. Those are the apartments that are owned by the city, but they're being self-managed by the tenants waiting to become co-op owners. In 2014, our organization actually impacted legislation because before you guys did not have succession rights. And starting back in 2014, you do have succession rights, identical to the rent stabilized succession rights we're talking about, including if you're senior and disabled, you only have to show 1 year of occupancy as opposed to 2. But if you live in a typical building, which is a city owned, and in case you're trying to figure out what these city owned buildings are, these buildings are with tenants that they were the ones that actually got all these, they cleaned up their own blocks and they've been self-managing all these shares. And there's still about 100 of them left in New York City. And they're still waiting to become homeowners. And our organization is working with them as part of a coalition.
Elsia?
She's frozen.
Yep, we'll see if she comes back on in a bit. While we wait for her to come back, we have another question here. One moment. And apologize if you covered this. What, if anything, can a co-resident in a rent-stabilized HPD apartment do that is trying to gain successorship if their parent passed away, but they cannot find any mail in the past 2 years before the TOR passed, only 4 or 5 years prior?
So Jesse, do you want to talk about HPD?
Sure. Just can you repeat the question? Was it an HPD apartment or was it a?
Sure. I apologize if you cover. What, if anything, can a co-resident in a rent-stabilized / HPD apartment do that is trying to gain successorship if their parent passed away, but they cannot find mail in the past 2 years before the TOR passed?
Yeah, so I'm not sure I really understand what we're asking. If it's a question of documents, then you got to sort of go with what you have, right? So, again, the issue with succession claims is that they're incredibly fact specific. So, again, I'm just not really sure if there's no documents. If that's what you're saying, there's no documents then that's something we should look at and talk about. If sometimes that happens, and it doesn't close the door on a succession claim. I don't want to sort of give the impression that if you don't have documents, you can't win, because that's not accurate either. You can. They just have to figure out ways to do it. Neighbors, lots of witnesses and testimony. It is possible, right? So that's the best I could do with that question.
My sister is the person who leased the apartment over 40 years ago. I lived with her in the apartment for at least 2 years before she moved out in 1973 when she got married. The apartment is still in her name, but I've been paying the rent since she moved out. I cannot find proof that I lived with her before she moved out because of how many decades ago she left the apartment. Am I able to claim succession rights? Is there any other way to prove I lived there before she moved out?
That's a tough one. And again, there's a lot going on there. I'm not sure if how the lease is getting signed every 2 years, if she's signing the lease, if the tenant is signing the lease. Again, these are very, very, very fact-specific questions. If you live in the Bronx or Manhattan, you might not get a chance to prove that you live with your sister.
I signed the lease.
You signed the lease?
Apartment is in Manhattan.
Well, if you sign the lease, then you don't have to succeed to anything.
No,
If,
I think that they're saying that they signed the lease probably under their name, under
if
the.
you sign, if you sign the lease under your own name, then maybe that's a different story. If you sign your sister's name,
And there should be no succession. It's prior to 1974 with rent
good question.
stabilization, so.
It's a
I
good
signed the
question.
lease, the apartment is in Manhattan, I signed my name.
Yeah, that's an interesting one because Cheryl brings up a really good point. 74 is when rent stabilization. It might be a rent control department, though you're saying that there's leases. It's hard to sort of get a grasp on the facts.
If you had your grandchild on already, can the landlord say, no, you can't keep your grandson or grandchild on the lease?
That's another fact-specific question. I'm not sure why he would want to remove the grandson from the lease. Is the grandson a minor or an adult that has a different residency?
Yeah, but even then, I mean, a landlord really can't unilaterally remove a named tenant from a lease, right? So if the individual, and people get confused a little bit about when they say name on a lease.
Yes, some
Sometimes
minors.
so sometimes there's like a place where you can write down an occupant or something, and there's varying sort of thoughts about whether people should do that or not do that. But if when we say on the lease, we mean when the lease gets mailed, there's the name at the top, and those are the names on the lease. If there's somewhere else like an occupant, and that's a different situation. If you're the named tenant on the lease, the landlord can't unilaterally just take your name off.
Right.
But it's hard to see why a landlord would have a minor child as a named tenant on a lease. That would be a little unusual.
I see a quick question here in Spanish. Hola, yo, ¿qué puedo hacer? Porque el dueño no me ha entregado mi lease.
That's a good question. Sure, you might be able to answer that one.
So you could work with Palente and they can assist you with filing a lease violation complaint.
That prior question, the person who asked it said, who can I speak to from Palante regarding this situation about the 1973?
Yeah, anybody can call, anybody can help, but you could ask for to speak to Chris Hasman, and just referred, that the person that you attended the Zoom call, and then we'll analyze your situation, the situation. Then, if need be, we could reach out to Sherelle, to Jesse, to all of our resources to see if we can get to the bottom of this. But like Jesse said, I think it's a very big difference between having your name on the lease on top and then you signing the lease at the bottom. And I'm afraid to ask, I do not know under whose name the rent is being paid to. So I hope it's under the tenant, the person who's signing at the bottom, and not the tenant from that's listed on top that's not occupying the apartment.
Can a superintendent's testimony verifying residency be enough to prove succession in court?
If the super wants to get fired, yeah. He'll be fired though. You can guarantee that would be the last time you see that super.
Yeah, don't depend on the super. That's the advice that I'll give on that. The super's an employee of the landlord, and but I mean, I guess if the super came in and said 100%, I see that guy every single day. He's in the apartment that would be pretty good testimony. You might be able to win a succession claim based on that. But again, that would be a first.
Yeah.
Grandparents pass away in a rent-stabilized apartment, and the grandson has all his documents mailed to the apartment, but he might fall short of the years living in the apartment. What can he do?
It has to be 2 years, right? If you're under 62, am I right, Sherelle?
Yes. Okay. So it's if you're under 62, you're not a senior citizen or disabled, then it has to be 2 years. I don't think there's any exception that's out there that can escape that 2-year time period.
No, it's harsh. It's 2 years and it's harsh. And if it's 1 year and 9 months, you're going to lose. I can't say that. If it's 2 years and 2 days, you're going to win. And that's the, I mean, there is a line, and it's 2 years. And it might be, it might be horrible and ridiculous, but that's what the law is at the moment. So it's not, well, it could be a little bit less if it's really compelling, or it could be a little bit less if it's, a child or no, it's 2 years. So if it's less than 2 years, you can't win. That's really what it comes down to.
Can I play the devil's advocate here though, Jesse? Because we had a
Of
case
course.
like that, but that was
Let's do
like
that.
right before the rent laws. We came across a case like that. So we went to the landlord and he said, well, clearly our client had no succession rights because of that 2-year rule. So we said to the landlord, well, what about if we pay you a vacancy increase?
Yeah, that's right. That's right. And now there is no more vacancy increase, and
I
that's
know
different.
that.
Right. Okay. But yeah, but that's a different. No, but LCMA is a really good point, and that's advocacy, and that's different. Nobody's saying give up. You might be able to do something to incentivize the landlord to recognize, and even now more than ever, right? So maybe that is something good to just hit on really quick. With the HSTPA, the Housing Stability Tenant Protection Act that Sherelle touched on,
The new rent
landlords.
laws.
The new rent laws, the
Okay.
landlords they're no longer entitled to deregulate an apartment. They're no longer entitled for a vacancy increase or a longevity increase, or just in the most extreme, like limited amount for any sort of improvements to an apartment. So there's no longer that great economic drive. There shouldn't be, although who knows what landlords are going to do or doing, or if they're going to follow the law, or what they're going to do, or warehouse apartments. But if they follow the law, getting rid of the person trying to succeed doesn't get them anything economically. It just gets them another renter in that apartment. And if they follow the law, pays the exact same rent as the person that left. So yeah, I've actually seen, since the passage of the HSTPA, landlords much more willing to recognize succession claims that might have been a little bit weaker or a little bit less, because in their minds, they're like, why not? Right. We know the family, and they're good tenants. They're good members of the community, whatever. And it's not all about money, because they don't really gain any money by turning the apartment over. That's a big change.
And that is, of course, before COVID. So if those negotiations, those are little negotiation taxes that we saw, but if the apartment above or below or next to is vacant, then the owner does have an incentive to
They
get
do.
it out,
They
because
do.
that means that they can combine those two apartments and say, gee, I can make this rent like 3,000. So, but if there isn't, and these are like little arguments that you can have with the landlord. Say, look, you can't, it's not like you can combine the apartments, right? If you don't have any vacant apartments above, below you, or next to you. These are like the little negotiating tactics that you could have. You don't necessarily need to have an attorney to do that. You could just have that conversation. Because you also have to look at the fact that the owner would also have to take you to court, even if you cannot approve succession rights. And that can go on for a long, long time, especially considering all the cases already pending. They're going to start in May, and then the ones are going to be filed in May. So, there are little negotiation tactics. So don't give up, is what we're trying to say. Next question.
If a succession person works in a different state and files taxes for that state required, and then also files for New York State 6 months each state, does this affect succession, i.e. employment in other state is required to file taxes for that state?
That's another fact-specific question, and how we're looking at taxes in terms of financial responsibility, where you live, and permanent residency. We would actually have to look at all the factors in that case to make a determination on how it would apply to succession.
If my rent is frozen using SCREE and my child later gets apartment, does it convert back to rent stabilization, or how will rent be determined?
Well, SCREE is only to a specific group of people. So if your child takes over in succession, it should go back to the regular rent. The SCREE should not apply.
If a tenant signs a lease with an unreported adult child in the unit and passes 2 months later, can the unauthorized occupant, while claiming succession, enforce the lease in effect without increase or penalty?
Well, that we go back to the 2-year requirement. If they sign a lease and they've only been in the apartment 2 years, they wouldn't be entitled to succession.
And we have a question about AR 23.5 form. Where can this form be obtained? I'm not clear if this is
Oh,
on.
we're going to follow up. Jakari is going to, I think you guys see him on the screen here. Say hello, Jakari. Jakari is gonna be a follow up with all of you folks with a copy of the 23.5 of that form. That's for those of you that join us later on. That's the, we call it the family composition form that DHC provides so that we could actually fill it out and give to the landlord. Now, correct me if I'm wrong, Sherelle, do we give that also a copy to DHCR or just the landlord, we keep a copy?
No, it's just the landlord. And you can keep a copy in your office if you'd like to, but it's just the landlord.
So we're gonna do that, and we're also going to provide you guys a copy with fact sheet number 30,
Yes.
so that you can just know about your rights. But I know we have a lot of clients that I want to put my son on the lease, and we tell them, look, let's do this form now, keep a copy of it, and let's make sure that we look at the 2 years before you leave the apartment. It's not that your child was born in the apartment or that's been living there forever. It's about those 2 years and the documentation that Jess and Cheryl were talking about. I mean, they're not looking at like cable bills, they're looking at government related correspondence like W-2s, your social security letter, um, anything from this, if you get food stamps, school letters. It's just like real documents that you need for your child, and you have to show that you both live together for 2 years before you left the apartment, whether you left voluntarily or involuntarily. And for those of you guys that, do not have the right to succeed, you have to understand that it's not like the landlord can just come and lock you out. The landlord cannot change the locks to your front door. The landlord has to take you to court, and you will, because we are in New York City, you will have your day in court. Also, before you get to court, you're going to be able to come copalante in court, assuming again that you don't have succession rights or whether you have succession rights. You're also going to get an attorney in housing court as part of the right to counsel. So don't leave your apartment just because you've been, staying there for a minute and you can't prove that you lived there 2 years before the tenant of record left. I mean, look, it also depends on the landlord. We have been successful in several cases of getting leases for people that absolutely have no right to the apartment whatsoever. So it's always worth giving us a call. Of course, all these conversations are confidential, and then we could give you the right tools and teach you the necessary steps on what you can do to remain in that apartment.
Does the rate stay the same when the rights transition?
Yes. When you get a lease renewal under your name, you have to understand that you're renewing the first lease. So whether it was your mom that signed the lease, whether it's your dad, whoever had that lease. So your lease will be a renewal lease that would be renewed under the same terms and conditions as a tenant of record that they had. So your security deposit transfers over, everything transfers over, and your rent will not change. The landlord cannot make, change his mind about late fees. I mean, whatever is on the original lease, which is what the lawyers, Sherelle and Jesse call vacancy. Whatever is on the vacancy lease, that is the lease. The renewal lease renews that other lease.
If I am in a rent stabilized apartment more than 15 years and my rent has been supplemented with HASA, can the landlord decide to not continue accepting the agency program?
Yeah, that would be discriminatory. Then the landlord can end up in a lot of trouble. A lot of trouble. So the landlord does not get to say that they do not want to have any subsidy, whether it's SCREE, whether it's Section 8, whether it's FES, whether it's HASA, whatever subsidy it is, the landlord cannot say, one, that he will not rent it to you because you have that subsidy, or the landlord cannot say, gee, I changed my mind, I'm no longer accepting the subsidy. So that would be totally illegal. So call us if the landlord is doing that. We we haven't fought lately with the landlord aggressively, and we would love to get a hold of that landlord if that's what they're doing. We need entertainment during COVID. Next question.
If an adult child has a disability, can rent remain same?
Jesse?
Meaning,
Yeah,
meaning what?
there- there's a program, it's called DRE, and it's similar to SCREE, which is the senior citizen, and this is the disabled rent increase exemption. So if the individual is disabled and you got to prove your disability, then yeah, you can avail yourself of those benefits and have your rent frozen.
Does rent renewal for SCREE person require to pay a deposit?
What's the question?
Does rent renewal for SCREE person require to pay a deposit?
You mean the difference of the security deposit? I think that's what they mean. You know how the increases have to be in line, Jesse, with the current month rent.
Mhm.
If you have DRE, if you have SCREE, you have to put towards your security deposit to be equal to 1 month's rent.
Well, that answers a yes. But it depends also on what Scree and DRE are offering in terms of the exemption towards the rent.
Next question.
We have a question in Spanish.
That's
Si
interesting.
un subinquilino que vive en un apartamento de HDFC por 2 años o más, esa persona tiene derecho a la sucesión del apartamento si el dueño lo abandonó.
It's an HDFC, Jesse.
Yeah, I mean, yes, in an HDFC you can succeed to a tenancy, but when the question asks vacated it, I'm not 100% sure what that means. Again, if it's a succession, if the tenant of record either passed away or left voluntarily, when I hear vacated, I'm not really sure what that entails. You have to meet the criteria for succession: family member, co-residency, and if you do that, you can succeed in an HDFC co-op apartment.
But these are HDFC rentals, not the co-op, or is it co-op, Jesse?
Oh, then in HDFC rentals,
I thought that maybe HDFC rentals would be, but if it's an owner, if it's the owner that vacates, are there succession rights to that? I mean, I would love to find out. I do not know.
No, there is. There's another criteria though, and they would then. I've talked about no economics. Here there would be some economics because you have to show that you are a financially responsible shareholder and that you could pay the maintenance going forward. But if you can, then yeah, at an HDFC co-op, yeah, yeah, absolutely, you get the opportunity to succeed. Yes.
That's wonderful. That's wonderful.
And that about brings us to the close of our long list of questions.
That's
Good.
it?
Yeah.
Well, this is great. Wow, we're a little bit we're a little bit late. We usually end at 8:30, Sherelle. But I'm glad that we answered all of the questions. Guys, again, thank you so much, Jesse. You know, you're our pana, you know, you're matatang. And
Exactly.
Sherelle, thank you so much for helping us.
Thank you.
Being able to answer these questions to these folks. Again, you know, I think that we covered a lot, but I think we were concise. And for those of you that have additional questions, feel free to call us. You could ask to speak to Christopher Hasman or Jonathan Betancourt or Jakadi, and they'll be able to speak with you. They're actually at the office physically, but not to see clients. They're there because of our mass distribution. But they're actually there live, that you could speak to them over the phone, and they'll get a hold of me, a hold of Jesse. We'll bring whatever resources we need. So what I'm trying to say is that while I'm not there physically, The housing specialists are there, and we're working on all the cases individually. So the sooner the better, because again, come April, things are going to get a little bit tough for us as an organization, simply because a lot of landlords are going to be taking a lot of families to court. So if this is a succession rights question that you have now, let's bring it in next week. Let's get you on the docket, and let's just respond. Let's get in front of it like we always do. And if I could just ask you guys, to take the survey. This is what we look at after each Zoom calls to make sure that we are doing what you want us to do. We're delivering the content and the expertise that is needed today. And again, Sherelle, thank you so much. You are the first DACR attorney that we had here. You're a woman of color. I just say it like that, okay? And we're very proud.
No, I was like, this is a little different. I was like,
I told you we were different. Palante is different.
Thank you. And if you guys ever need anything, you have my contact information. Feel free to reach out.
Thank you.
Jesse, I'll shoot you an email.
Please.
And I'm here to help.
Thank you.
Thank
Thank you,
you.
Jesse. Have a great night, everyone.
Yeah, everybody. Be well.
Awesome
Thank you.
weekend.
Have a
Stay
good one.
safe.
Thank
Stay